Hello, everyone, and thank you for joining us for today's webinar. I'm Dr. Melanie Reese, Director of CADRE, and I'm joined by CADRE's staff, Noella Bernal and Kelly Rauscher. As National Center for Appropriate Dispute Resolution, CADRE is delighted to offer another in our expansive series of free, high-quality webinars on issues important and relevant to the field. This webinar will be recorded and archived on our website. The recording, as well as the materials for this presentation, will be found on the website. I will also put a link in the chat on where you can find it, and we will also add them to the chat here as well. Chat. I'm leaving this page up so that folks who would like to find the information for translation and ASL interpretation can find it. Today's 90-minute webinar is being translated simultaneously into Spanish and into American Sign Language. To access the accessibility features, please follow these instructions. All lines are muted. Please post your questions in the question box. I will be collecting the questions, and Art will take questions after each section of his presentation. All questions will be posed as hypothetical situations and not as case-specific scenarios, and the presenter will not be providing any legal advice. We may not have time to address all of the questions to ask, but we will attempt to address those with the broadest application in order for Art to get through his material. And thank you in advance for taking the time to respond to the brief survey at the end of the presentation. Your feedback is very important for CADRE's ability to continue to bring you webinars such as this one. And finally, this webinar will be posted and archived on CADRE's website at the link that I've also put in the chat. Here is our standard legal disclaimer. The information shared on this webinar is not intended to serve as, nor should it replace, legal advice. Opinions expressed by today's presenter are not represented to be an official or unofficial interpretation of legal guidance from the U.S. Department of Education or from CADRE. Application of information presented may be affected by state statutes, regulations, local policies and practices, and unique fact patterns of a particular case. Again, the materials for today's presentations are available on our website, but I will also post them very quickly here in the chat for you as well. So here they are in the chat, and here is the document. So with that, let me introduce Art. Many of us know Art Cernosia through his long and distinguished career providing training, consultation, and technical assistance to states, parent centers, districts, and other organizations, and his many years of presenting at special education law conferences. And CADRE has been in the enviable position of working with Art as our legal consultant since 2018. And I've known Art since 2009, where the state I was working in had contracted him for legal consultation and training of dispute resolution practitioners. And I have personally benefited greatly from his encyclopedic knowledge of IDEA, his insights into the finer points of the law, and his unwavering focus on the benefits of building and improving relationships to best serve children with disabilities. And one thing out of many that I admire about Art is that his true north, his heart, is of service and creating environments that work to improve systems for infants, toddlers, children, and youth with disabilities. He is a champion for including everyone at the table. I remember when I would have a training at the state agency, he would always ask, are parents or the parent center going to be invited? He truly takes a systems perspective and weighs carefully how everyone is impacted, and I've appreciated his mentorship and friendship beyond measure. He's been threatening to retire since the day I met him, but CADRE is fortunate to still have access to his wealth of knowledge and experience. He is truly one of the best people. And with that, I hand the mic over to Art Cernosia.
Well, good afternoon for my friends on the East Coast, my friends in the Central and Mountain time zones. Good morning to my friends out West, and aloha to my friends in Hawaii. And thank you again, Melanie, and my friends at CADRE for this opportunity. So today I'm going to be focusing on IDEA cases from 2024, significant legal cases that I have chosen with one exception, and we'll get to that shortly. For those of you who are hearing officers or complaint investigators who make legal determinations, I encourage you to read these cases that I'm talking about in full and make your own determinations of the relevancy to the issues that are in front of you. As you know, in every single case, there's multiple issues addressed by the courts. I may have selected one or two of the issues. I know nothing about these cases other than what the court has shared with us. In some cases where the Court of Appeals has just affirmed the district court, I read the district court cases to get more specific fact situations that I will be sharing with you. As Melanie pointed out in one of her slides, you also need to be aware of any state-specific requirements in your state that may add to IDEA requirements. After each case, I'm going to be accepting any questions about the issue or the cases, and we will see how many questions or comments that time allows. With that, Melanie has been kind enough. She is going to be my slide advancer. So next slide. This is the one case that is not in the IDEA. This is the one case that is not in your materials. It is a Supreme Court case that had nothing directly to do with the IDEA. In June of this year, in a 6-3 decision, the Supreme Court overturned what has been referred to as the Chevron Doctrine. Now, what does that mean? That means prior to this case, when courts were looking at federal interpretations, let's make it special ed specific, IDEA regulations, IDEA interpretations, the Chevron Doctrine said that the courts must give deference to those administrative determinations. That has now changed. The Chevron Doctrine has been overturned by the current Supreme Court. Now the Supreme Court said courts must give their independent judgment to decide whether the agency acted within the authority given to them by the statute when they promulgate regulations, and they can no longer defer to the agency's interpretation of the law when the statute is unclear or ambiguous. Next slide. So how does this apply to special education? Well, first of all, it's still being litigated. There are a few special education legal actions pending that are questioning the authority of the U.S. Department of Education to order or enforce their regulations or interpretations when the statute is unclear. So we have not yet received any follow-up judicial interpretations of how this Supreme Court specifically impacts special ed law. But let me give you a couple examples of, in special education, IDEA regulations that I think are subject to challenge. One, the state administrative complaint system. As you know, in addition to mediation, in addition to filing for a due process hearing, I, as a parent, I, as a concerned citizen, I, as an organization, could file a complaint with my State Department of Education and alleging that the school district, charter school, et cetera, is not in compliance with the IDEA. The state administrative complaint system is not even in the IDEA statute. It's in another statute called the General Education Provisions Act, which basically said the Secretary of Education shall promulgate regulations to enforce the law. So it's very open-ended and arguably ambiguous. We will see how the Loper decision will be applicable to state complaint systems. First of all, little caution. I am not saying that the state administrative complaint system is no longer valid. What I'm saying is it'll be subject to potential challenge as a result of the Loper decision. The same thing with independent educational evaluations. The only place in the IDEA that independent evaluations is discussed is in section 1415 of the statute, which says that procedural safeguards include the right to an independent educational evaluation. It doesn't even mention a right to a public payment of the independent evaluation. That was all the result of promulgation of regulations that go back for decades. I think arguably the statute is ambiguous and potentially could be subject to legal challenge under the Loper decision. The Office of Special Ed Programs, OSEP, issues policy clarifications, memos, Q&A documents, and they make clear in those documents that those policy guidance do not have the force of law. However, courts have relied on them in large measure at times when making a determination in a given case. As a result of the Loper decision, I think that will be very questionable whether a court can rely on or cite a OSEP policy determination in one of their decisions. So we'll see where this takes us, but I wanted just to open this seminar or webinar on the fact that special ed law indeed may be changing as a result of this recent Supreme Court decision. Now let's get into IDEA cases. Next slide, please. And I'm going to be talking about issues from eligibility to staffing to least restrictive environment. So I'm going to try to cover the spectrum, so to speak, of IDEA issues. In this case, from the Fourth Circuit, U.S. Court of Appeals. And by the way, for those of you who have access to the outline that's posted on CADRE's website, the outline will have more specific information regarding each case, including the citation to all these cases. But in the Fourth Circuit case, here was a child in second grade, was not IEP eligible, but the parents were concerned that the child was struggling with reading and writing. The test scores of this child were declining, so they asked the school for a special ed evaluation to determine whether the child was eligible under the specific learning disability or other health impaired categories. The school district agreed to the evaluation and conducted the evaluation. The team met and determined the child was not eligible for special education. It gets up to the Court of Appeals, the level of court right under the Supreme Court. The Court of Appeals upheld the team's determination. Regarding specific learning disabilities, the court held that the evidence did not show that the child had a pattern of strengths and weaknesses, either in performance or achievement, regarding age standards or grade level standards. The parents cited one test score which showed a decline. The court said, when we look at the eligibility determination, two things. First of all, it's a team decision and it must be made on a variety of information, multiple sources of data. So the court held the child did not qualify under the SLD category. Under OHI, other health impaired, the child did have an ADHD that was acknowledged by the team. However, the team held that the student did not qualify because the child did not need, as a result of the diagnosis, did not need special education. Again, the court upheld that decision and finding that the child was already receiving services that allowed the child to make progress in second grade and receive passing marks. And there was no mention in the decision of any behavioral problems that were interfering with the child's learning. A couple things, and this applies equally to experts from the school district and experts from the parent. In this case, the parent obtained two independent educational evaluations. One evaluator diagnosed a child as having dyslexia and dysgraphia. Those IEEs were considered by the team. Regarding the presentation of evidence, the court upheld the credibility determination by the hearing officer or administrative law judge in this case, that one of the experts who testified had met the student 1 hour before they testified. The other expert acknowledged that they had never met the student before testifying. Interesting to note that the professionals who conducted the independent educational evaluations were not called as a witness by either party. So the school witnesses were determined to be more credible. And I have seen cases where school experts have based their testimony solely on a record review. I'm going to have the same questions regarding the credibility of their testimony if they had never met the student, never observed the student in a classroom setting, never spoke to the child's parents or teachers. The goal in this, hopefully under the law, is not to comply with the law, it's to make good decisions for children. So the lesson learned, next slide, please. First of all, a diagnosis alone is insufficient to determine whether or not the child qualifies under the IDEA. Now, as a parent, if my child receives a diagnosis from a professional, my expectations will rise significantly. However, again, the team, and I'm a member as a parent of the team, based on multiple sources of information in the evaluation, must determine 3 questions: whether or not the child has 1 or more disabilities under the IDEA. If so, whether that disability adversely affects the child's educational performance. And thirdly, whether the child is in need of special education. As I mentioned, in this case, there were independent educational evaluations that must be considered by the team. And the team needs to issue a PWN, prior written notice, if they are either proposing or refusing to implement the recommendations contained in the independent evaluations. And if I could just highlight that the word team, I have heard in too many cases where the team looks at one individual, such as a school psychologist, and said, did this child qualify? Again, this is intended to be a team determination, and no one team member will make that determination in isolation. Now, we're going to take a few minutes and see if there are any questions or comments on the issue of eligibility or this particular case. And I'll turn to my friend Melanie, who will read any questions or comments.
Art, there weren't any questions regarding this particular case, but there was calling back to the looper analysis. Do you think that the looper analysis will apply if state statute or regulations provide for state complaint investigations or the public payment for an IEE?
Well, first of all, if I was a state complaint person, I am not suggesting that the IEE regulations are no longer valid. I'm suggesting under the Loper decision, they're certainly subject to challenge. That is not for me, the complaint investigator, to make a determination whether the federal regulations that have been promulgated are valid under the recent Supreme Court decision. So if I'm a complaint investigator, I must consider not only the IDEA regulations, but any state regulations, and making a determination of whether minimum legal compliance was achieved under the circumstances.
There was a follow-up. Does the IEP stand as prior written notice, or do you suggest a separate letter to family?
The U.S. Department of Education has said that technically a prior written notice could be included in the IEP. But if you look at the requirements of a prior written notice under the federal regulations, and I just happen to have them here in front of me, the federal regulations, if 300.5, excuse me, getting over a cold, excuse me, 300.503 contain multiple parts of information, not only the decision made, but an explanation of why it was proposed or refused. What did the team consider regarding each evaluation they considered or assessment? Other information that was relevant for the team's consideration. I have yet to see an IEP that contains all that information. So I believe most states and most LEAs, local education agencies, that includes charter schools, they provide a PWN or prior written notice separate from the IEP because of the multiple pieces of information that are required to be in a prior written notice. And with that, I think we're going to move to our next case. This case comes out of the great state of Hawaii, EW versus Hawaii from the Ninth Circuit Court of Appeals. Now, in this case, here was a child with autism that was attending a private special ed school. The IEP that was developed called for this child to return to the public school. The parent of this child who has autism challenged that IEP on two procedural points that I wanted to raise. They argued that the IEP was inappropriate because it did not include a behavior intervention plan, or BIP, as we refer to it, nor did it include transition services. The court upheld the IEP. The court said, first of all, FAPE was provided. What's legally required regarding behavior? If behavior is interfering with the student's learning or the learning of others, the IEP has to include supports, interventions, and strategies, positive supports, interventions, and strategies that will address that behavior. This IEP included behavioral goals and did include those supports and interventions. The court noted that the term BIP, Behavior Intervention Plan, is only used under the IDEA in a disciplinary context. And even then, there is no definition of a BIP. In this case, the term Behavior Intervention Plan was used in the context based on the testimony of a behavioral consultant that said, in this case, separate from the IEP, we had a behavioral intervention plan that was really a training document designed to assist us in training the individuals who'll be working with the student. The court held that there was no violation of the IDEA. Secondly, transition, as was used in this case. The parent argued that transition was not included, which was supports and services to move the student from the private school setting to the public school setting. How does the IDEA use the term transition? The term transition as used in the IDEA is used for those students who are usually of high school age in transitioning to post-secondary environments. What do we need to do now to support that child from obtaining their post-secondary goals? That's not how it was used in this case. So what is the lesson learned? Next slide, please. We need to read these cases very carefully, and we need to determine how particular terms are being used in the context of the case. Remember, again, in this case, a behavior intervention plan was used as a training document for staff. The IEP did include behavioral goals, behavioral interventions, and supports, so it met the IDEA requirement. Now, my friends at the U.S. Department of Education, OSEP, have issued several Q&A documents regarding discipline, the most recent in 2022. In that document, OSEP has said that the term behavior intervention plan is used designed to address behaviors that interfere with the child's learning or that of others. Well, that's not how the IDEA uses that term. In fact, as I pointed out, it's used only in discipline. Even then, there is no definition. The OSEP guidance goes further to say that if a BIP is needed, either to support that child so the child's behavior doesn't interfere with their learning, or in a disciplinary context, it must be included in the IEP. So I wanted to point out that in my opinion, the OSEP guidance is useful. However, it provides a broader interpretation than that in the IDEA. And for those of you who are want the information of where the OSEP guidance is contained, it's in a 2022 Q&A, and it could be found on Special Ed Connection at volume 81, page 138 of the IDELR. Questions?
I'm looking. There was a comment, a parent is a full member of the IEP team. If the parent as a member disagrees with the decision, then is there no decision? And the next step is mediation or impartial hearing?
The goal of a team is to reach consensus. But there are sometimes, even after a good faith attempt, that we just will have honest differences of opinion. A parent is a member of the IEP team. However, if I, the parent, disagree with my school colleagues on the team, there has to be a decision that's made at the team meeting, so that one of the required members is a LEA representative who has the authority to make decisions. So that person would make the decision at the meeting. I would get prior written notice of why my position, why the team has disagreed, why they are refusing to make the change that I feel is necessary for my child. And then it would be up to me, the parent, either to request mediation, which is a voluntary process, file a state administrative complaint, or file a due process hearing. The one exception, if this is the initial IEP, the school needs to get my written consent before that IEP is implemented. That's just for the first IEP.
There were some follow-up questions around.
Anything else, Melanie?
Yeah, there were some questions around behavioral intervention plans. So is there any reason that she can't use transition services, or can a behavioral intervention plan be a staff training document? Is there any reason she can't use transition services in that way? Was the question. I'm not sure what the
I'm not quite certain. In this case, by the way, there were supports to make sure to the best extent possible, this student would be successful in moving back from the private to the public school. But it need not be included in the IEP, according to the Ninth Circuit Court of Appeals. So I would really recommend moving away from the term transition and behavior intervention plans unless those terms are clearly defined under your state law, because otherwise I think it could be confusing to both the parent and the school. In other words, using the term transition as it's used in the IDEA to talk about service and supports necessary to provide movement to post-school activities, post-secondary activities.
Another question, is the EW decision saying that the OSEP guidance is in conflict with the IDEA about behavior intervention plans being required? And can the family say a BIP is required if behavior plan is listed as an accommodation?
The last two bullet points on lesson learned are arts inclusion. The Ninth Circuit did not address the OSEP guidance. I wanted to point out how, if I read the OSEP guidance, in my opinion, it goes beyond how that term is used in the IDEA statute and regulations, and therefore it's somewhat confusing. So I just want to make clear the Ninth Circuit did not address the OSEP guidance. that was an added feature that a bonus, so to speak, that I want to put in there to talk about how OSEP is defining the terms broader than they are in the law.
Um,
And I would again, unless your state law or regulation talks about behavior intervention plans other than a disciplinary context, I would keep it. I talk about behavioral components of the IEP, the cognitive positive intervention strategies and supports that a particular child may need. I think we're going to the next slide, please.
okay.
We're on a theme here, behavior supports. This is a Third Circuit case from the East Coast, my friends in Pennsylvania and New Jersey in particular. In this case, here was a child who had been placed in 2020 by the IEP team in a private special ed school. The child was struggling, especially with behaviors. The parent obtained 2 independent educational evaluations. Both IEEs recommended that the child get a functional behavioral analysis, a FBA, and a behavior support plan. I wanted just to make a note, and it's included in my outline. In Pennsylvania, if a child's behavior is interfering with their learning, the state regulations require that the child receive an FBA leading to a behavior support plan. Those terms are not defined in the IDEA. So I wanted to, this is an instance where state-specific use of terms comes into play. However, the team considered both independent educational evaluations and did not incorporate the recommendations of conducting an FBA leading to a behavior support plan because they said the private school had a school-wide plan. Remember the term PBIS? That where school systems, particular school districts would have adopted a kind of a comprehensive systems behavior plan to support students, all students, not just students with disabilities. Here, the team, in fact, incorporated in the IEP the school-wide behavior plan. It did not individualize the plan, but just made mention of it and said, we incorporated in the IEP those supports that are included in the school-wide plan. It gets up to the Third Circuit, the court that FAPE was denied because the school was on notice and it was clear that the child was struggling with behavior. And it was clear from the IEEs that the child needed a behavioral FBA and a behavior support plan as used, those terms are used in Pennsylvania. Reference to a school-wide plan is insufficient. There were no individual behavioral goals. There was no provision in the IEP to address how the child was progressing under their goals. So if we move to the next slide, what was missing was the I in the IEP. In other words, just by referencing in the IEP a school-wide behavioral plan is not going to meet the requirements of the IDEA. In this case, as a result of denial of FAPE, the school was ordered to provide 1,800 hours of compensatory education. Let me repeat that, 1,800 hours of compensatory education at a cost of $128,000. Another lesson learned here is that when the local education agency, and that includes charter schools, when the LEA of legal residence develops an IEP and places that child outside the school district or the LEA, such as a private special ed school, the LEA of legal residence maintains full legal responsibility for FAPE. They cannot delegate that responsibility to others. Bottom line, The buck stops there. And in this case, among other things, the school said 1,800 hours of compensatory education. That's crazy. That's not a verbatim quote. The court held an award of compensatory education is going to be upheld as long as the hearing officer or court, whatever body ordered it, gives us their rationale of how they've achieved that particular level of compensatory education. And this is true in particular when schools have put on notice that they should have been aware that the IEP was not appropriate. Questions?
Yeah, yes, there are a couple questions. Should a school continue to provide IEP services while waiting for an IEE results after a child was found ineligible through the school's evaluation, or should the child remain on the IEP while waiting for those new results?
What they teach us in law school to say is, it depends. Should the child receive services while awaiting the IEE if found ineligible? So let me play two scenarios. If the child had been on an IEP and the team finds that the child is no longer eligible and the parents are getting an IEE, I think that's an invitation for the parent and school to discuss, can we agree to continue services until we get the IEE report in, and maybe even define a period of time by which it will be submitted. And I think that would be voluntary. If the child has never been found eligible for special education, there is no legal requirement to provide services pending the results of an IEE. But I believe a school district's going to get two different responses to their finding that my child is not eligible. If you're saying, well, Art, your child doesn't qualify for special ed, you have a nice day. Well, that's one scenario. The other scenario is your child does not qualify for IEP services, Art, but here's what we believe we can do in terms of supporting your child's success, whether it be academically or behaviorally. I believe that second scenario is going to have a different reaction from the parent, and again, is going to, I think, enhance the collaborative relationship between the family and the school. Next question.
If it's a triannual IEP, the team can stop services if they believe the IEP is no longer required without parent consent?
There's no such thing as a triangular IEP. There is a requirement that a reevaluation be conducted at least every 3 years, unless it is determined that a reevaluation is more frequent or the parent and the school district otherwise agree. But I'm not sure what a triangular IEP is.
I think they meant the triennial evaluation or a 3-year evaluation. I think that was the confusion.
If my child has been on an IEP and a reevaluation has determined they no longer qualify for special education, and I'm assuming that's part of a reevaluation that the parent has been provided a full opportunity to participate, the team must provide me prior written notice of that decision, even if I was at the meeting, and they would provide a date by which services would be stopped. Now, if I challenge that IEP by requesting a due process hearing, then arguably a stay put provision would kick in, maintaining services.
There was a follow-up question to where do those 1,800 hours come from? Does the student receive those services outside of the normal school day?
The court was somewhat generous in saying that's for you to figure out. You could use contracted individuals, you could use school staff. They did not specify how to. That's a lot of hours. And as a parent, I'm not sure I want my child to spending every waking moment outside the regular school day and the regular school year in receiving compensatory education. And that certainly is going to take more than 1 year, because OSIP said that corrective actions should be fully implemented within 1 year. This would be one of those exceptions. And so I think, again, that would be subject to some negotiation with the parent about how those services will be provided. And I know of cases where the parent says, I don't want 1,800 hours. Here's what I would like. And it might be something less than that.
There was a clarification that in California, a reassessment is called a triannual. So it's just a statement.
It's a triannual assessment.
Correct.
I thought the term
the question was
a triannual IEP.
The question did say triannual IEP, which was incorrect. Triennial. So there's a comment. I agree with comp ed outside the school day. Are schools then required to permit providers to come in during the school day?
To permit providers, remember, comp ed is the school district's responsibility. It is not the parent's responsibility. So the school district could contract with private providers, and it's up to the school district whether they will supplement or provide that comp ed during free periods during the school day, after school, before school, on the weekends, over the summer. The court in this case did not specify how that's to be implemented. And I'm going to need to move on. Next question, next case. IEPs and evaluations for students with disabilities who've been placed in private schools by their parents. Now, this is another case from the Ninth Circuit Court of Appeals, and you will see a lot of cases in my outline from the Ninth Circuit. One of the reasons is the Ninth Circuit is the largest circuit in the country and probably issues more cases than most of the other circuits combined. So I did not pick out the Ninth Circuit for any other reason. In this case, Newport Mesa versus DA, here were a parent who was very unhappy with their child's IEP in school, removed their child from the public school and placed their child in a private school. The school district sent the parent a letter then saying, well, we understand your decision was to place your child in a private special ed school. Please inform us if you would like us to hold an annual IEP meeting while your child attends the private school. The parent never responded to that letter. The parent then initiated a due process hearing seeking reimbursement for the tuition for the private school. And a great deal of the discussion in the Ninth Circuit case was based on alleged procedural violations. One, the parent argued that the school never updated my child's IEP. An IEP must be updated annually. The court held no procedural violations. When a student with a disability is attending a private school placed there by the parents, the school district needs to either develop or review that IEP only if the parents ask for such a review. And remember, in this case, the parent did not. There was also a 5-week delay in the triannual, as the questioner asked, or the 3-year reevaluation. The court held there was a 5-week violation. However, it was a harmless error because there was no evidence that it resulted either in a loss of educational opportunity to the student or significantly impacted my decision-making authority as a parent. There is another case that I cited in my outline that's kind of a companion case called JB versus Cryon, CYRENE. It's in the outline. And a very similar situation where the parents place their child unilaterally in a private school. The school district was attempting to do the reevaluation. However, the parents put several conditions on that reevaluation. Ultimately, the Ninth Circuit held that since the parent did not consent to a reevaluation, the school district's obligations under under the IDEA and so I'm going to suggest that it's essential best practice when a parent places a child in a private school to inform the parent in writing of their right to ask for an annual IEP review. Remember, the court said schools are not required to provide an annual IEP review unless the parents ask for one. But first of all, inform the parent of my right to ask for one. The district did so in this case. However, the parent never followed up. Also, Melly, I don't see the next slide. Can you hear me? There it is. The second bullet, the reevaluation has to be conducted every 3 years. And one of the purposes of a reevaluation is to determine continued eligibility. And again, the court in the in the companion JB case held that the parent's refusal to consent to that reevaluation ended the school's obligation to provide FAPE. However, remember, the school still potentially has an obligation to factor in that student to receive services under a service plan. And the law has taught us that procedural violations will result in a denial of FAPE only if we answer the so what question. So what effect did the procedural violation have either on the child's opportunity to receive educational benefit, the parent's opportunity to participate in the decisions? If it didn't, otherwise it would be a harmless error. I am not suggesting to school districts that you just do your best to comply with procedures. What I'm suggesting is that the law says that procedural violations would only lead to a denial of FAPE if the so what question is asked. By the way, if that same case went to a state complaint, state departments of education are held to a 100% compliance standard. So if any violation occurs, the state will issue a finding and a required corrective action. Questions?
Well, there was a thank you for bringing up some of the challenges in federal statute and regulations. This person's been long aware of the challenges. The question is, if the federal regulations require a behavior assessment and it is determined by the team members that this assessment is necessary as part of the manifestation determination, is consent from the parents or student who has reached age of majority required to conduct this assessment?
I will again say it depends. I have seen at times for manifestation that the team is collecting existing information, observations from the teachers and other service providers, a review of the educational records, including the behavioral records or disciplinary records of the student, input from the parents. That would not require consent. However, we want to do a more formalized assessment, such as an FBA or other type of behavioral assessment that requires more than a review of existing information that would require consent.
And the question is, I see some schools are called private special education schools. Are these non-public schools? I typically think of private schools as general education school paid for with parent funds.
In my travels around the country, there are some states that call private special ed schools non-public schools. Other states call them private schools. In Art's opinion, they're the same. And by the way, in order to be reimbursed for my placement as a parent in a private school, the Supreme Court has held that that school doesn't necessarily need to meet the same standards as a public school in terms of staff credentialing and approval by the state. Although those would be relevant, that would be relevant evidence in determining whether such a school is proper for the student. Next slide, please.
Okay.
Next slide, please. State dyslexia laws, state laws. Virtually every state that I am aware of, with maybe a handful of exemptions, has a state dyslexia law now. This case came from Tennessee, and in this case, the court, here was a state where the state dyslexia law was in the general education statutes and specialties. And if the student was identified as having dyslexia, specific dyslexia interventions had to be provided under a tiered support system. Well, in this case, here was a child on an IEP. The parent also got an independent evaluation that identified the child as having dyslexia. The parent paid for and provided private tutoring for dyslexia, where the tutor used the Wilson Reading Program. The IEP for that student did address reading, but focused on fluency and expression and not basic reading skills. The parent went to a due process hearing challenging the IEP. During the course of the hearing, the parent acknowledged that this child was on pace to graduate. In fact, this child had a GPA of 3.4 and was on track to graduate with a regular high school diploma. In this case, the ALJ, or hearing officer, found that FAPE was denied. The court agreed. The court agreed and said that that was a proper consideration in a due process hearing, because the definition of FAPE includes meeting the state standards of the SCA. And the court held that the IDEA makes no distinction between state special ed standards and state general ed standards. So even though the state dyslexia law was not in the special ed statutes, but was in the general ed statutes, the court said it was a proper consideration for the hearing officer and upheld the hearing officer's conclusion. In addition, this student used assistive technology heavily. And this was in one of the first cases where I've seen AI used. And the child also used speech-to-text software. The court held the over-reliance of technology in significant part played a role in the student doing well and kind of masking their lack of basic reading skills because of their use of artificial intelligence and other AT software. Next slide, please. Lesson learned. Virtually every state out there now has a state dyslexia law. It's going to take some close review of your laws, any regulations, any guidance from your State Department of Education to determine whether those state dyslexia laws impose a legal obligation on a school district or charter school regarding assessments, regarding services, or supports. Second lesson learned, grades will not always be determinative of FAPE. One of the basic lessons that the IDEA has taught us, it's team decisions based on multiple pieces of information. As a former teacher, most of you who are school district employees or State Department employees have taught somewhere in your career. You know that the awarding of grades has somewhat of a subjective element to it. Grades could be relevant, but they're not determinative. But one of the lessons learned from this case is we need to determine whether there's any intervening factors, such as the over-reliance on assistive technology that may be masking the skill that was attempted to be learned by that student. And I think the challenge becomes even greater with the greater use and reliance on artificial intelligence. Questions, comments?
There aren't any comments or questions specifically on this topic.
Okay, this is the only judicial case that I'm aware of that delved into a state dyslexia law and applied it to an IDEA proceeding. So we'll see whether this is an outlier or it becomes part of the IDEA analysis. Next slide, please.
There was a comment that some states do not have a state dyslexia law. So.
And that I made mention, the vast majority. In fact, I did a Google search, and I don't want to put all my marbles in that basket, but they said 45 states do.
Okay.
Did not list the 3 states that don't.
A question came in: if the parent had supported the use of AT, does that make a difference in the outcome, or is that irrelevant?
I think what's gonna be relevant is what the IEP says and not what the parent had agreed to outside the IEP context. And I think the teams need to consider, of course, every student with a disability potentially has a need for assistive technology, but we have to determine what's the purpose of the assistive technology, how it will be used, and it should not be in place of acquiring the basic skill area. So I think in terms of the analysis, we would look at what the IEP says in terms of the use of assistive technology and the purpose.
I don't know if the case spoke to the grade level of the student or what grade for dyslexia, and was grade the issue?
Well, the grades were not the issue per se, but there was an argument by the district. This kid has a GPA of 3.4. They're going to graduate with a regular diploma. Obviously, they're doing well. So what's the problem? That's when the court came in to say grades are not necessarily determinative of FAPE, because in this case, the court was persuaded based on the evidence that in large measure, the basic reading skill acquisition of the child was lacking due to their over-reliance on assistive technologies such as artificial intelligence and other software.
Would you think that analysis also applies to state restraint and seclusion laws?
Well, well, first of all, that's going to be a little bit of a jump from dyslexia laws to state restraint and seclusion laws. But let me just say that the state restraint and seclusion laws that I recall reviewing do create a legal requirement and a legal obligation on the part of schools in addressing problematic behavior and the potential use or misuse of restraint and seclusion. So I think it's a closer call for state restraint laws as opposed to a state dyslexia law. Next slide, please. Extended day services. Here's a child with epilepsy and had a unique form of epilepsy. The doctor said that this child has seizures all day long, but especially in the morning, and cannot attend school in the morning. Key point here, the school district agreed with the doctor. The previous school district in another state provided afternoon and evening services to the student. The parent moved to a new state, asked for the same type of schedule. The school district denied their request. The court found, the Eighth Circuit Court of Appeals found that there were quote unquote shifting explanations on the part of the school in denying those services. First, they said, well, the IDEA doesn't require us to provide services outside regular school hours. Secondly, they said it would set a bad precedent in this district. Thirdly, they said if we're asked to provide services in the home, that's too restrictive of a placement. The court said A+ for creativity, F for content. Again, not to quote them. But the court made it clear the IDA does not limit services during regular school hours. In this case, the evidence showed the child had not achieved any of their goals for 2 years, that they made quote unquote de minimis progress with just afternoon services is what the school initially provided, in particular on independent skills such as toileting. In this case, the court said the school must provide afternoon services at school and then supplement that with a 4:30 to 6 o'clock service provision in the home. And they also ordered 495 hours of compensatory education. And before you even asked, the court didn't say, how is the 494 hours going to be provided? The court left that to the parties to figure out. But the court did not enunciate a specific method of providing those services. Next slide. Although the IDEA addresses extended school year, the term extended school day is not used in the IDEA. But the courts, in the few cases that have happened, have used the same analysis. And again, this is the U.S. Court of Appeals for the Eighth Circuit. And let's remember the Andrew F. Supreme Court case said when a parent challenges a decision, the school must provide, quote, a cogent and responsive explanation for its decisions, end quote. Court said the school failed to do so here. The court said in this case, the school seemed to focus on administrative convenience, staffing convenience, and I'm going to add budgetary convenience. The court said, therefore, the school did not meet the standard in Andrew F. And one of the very important things in this case, and we'll see a theme here, not only academic, but non-academic needs of a student must be considered. In this case, it was independent skills such as toileting that the court focused on. Questions regarding an extended school day?
No questions have come in about this case.
Let's move to extended school year. Next slide. Here's a child with autism and an intellectual disability, 10 years old. Everybody agreed. The team agreed this child needed an extended school year program due to the child's behavior and independent skills. Toileting, again, is what the focus on. There was no dispute that this child was making academic progress. So for the need for ESY programs were on those non-academic areas of behavior and independence. The team met several times and ultimately proposed 6 weeks of extended school year program, 4 hours a day, 4 days a week, because that's how our ESY program is structured. The parent said, that's not going to work. My child needs more than that. And moreover, I work. So I am asking for full day ESY programs. And I'm asking for programs not just for 6 weeks over the summer, but for all of June, July, and August until school starts. By the way, I would also like services over Thanksgiving and Christmas breaks. It got to due process. It gets up to the Texas District Court. The court ordered that the school district the team was making the decision based on the program schedule and not on the individual needs of this student. In this case, the court ordered extended school year services for June, July, and August, 4 days per week, 4 hours per day, and again, provided by personnel either that were district employees or contracted individuals. The court denied the request of the parent for full day extended school year services and for services over holidays. But the court said that there was data to show that the student regressed, in particular with elopement, that means what? Running away, and toileting skills under their independent goals, and therefore needed a greater extended school year program than what the IEP team was offering. Next slide, please. The lesson learned. Obviously, we have an extended school year program that we have put together as a district. That doesn't limit the team in making individualized decisions of what the student needs. This again, and I'll just restate it, non-academic needs were the main concern that supported the need for the court's decision of a greater amount of extended school year services. However, the court did find that legitimate family needs for full-day childcare do not translate into the responsibility of the school district. And because I'm on a timeline, I'm going to move to the next slide because I want to make sure we get through this. Transportation as a related service from the Court of Appeals from the District of Columbia. And this is, again, the Federal Court of Appeals. A student who is medically fragile, nonverbal, wheelchair bound, lives in an apartment that is non-accessible. It's 14 steps from the apartment door to the street where the school bus would pick the child up. The mother has a medical problem that limits her ability to pick the student and wheelchair up. And dad's work schedule doesn't allow him to be there every morning. The school district has a policy based on their safety concerns that prohibits a staff member from entering an apartment building or lifting or carrying a student under transportation. Now, a little quirk in this case. This child attended a public charter school in DC. However, in DC, the school district provides all related services such as transportation for children with disabilities, including children who attend charter schools. By the way, the IEP team in the charter school called for door-to-door transportation. They did so as a means of challenging the local district policy that put limits on door-to-door. It gets up to the Court of Appeals. The Court of Appeals reversed the lower court and held that the related service of transportation under the IDEA requires, as necessary, door-to-door transportation. They quoted the statute that defined transportation as may be required to assist a child to benefit from their special ed. The court said, how can this child benefit from their special education program if they can't get there? Therefore, in this case, based on these facts, it was deemed a necessary related service to be provided at no cost to the parent. Next slide, please. Lesson learned. Local policies will not insulate you from IDEA responsibilities. Your local policy must be in concert with any state or federal legal requirements. The court found in this case that the local policy on transportation was unduly narrow. Also, in this case, if you recall, the charter school IEP team developed an IEP that called for door-to-door. That becomes the responsibility under the DC policy of the DC school district is to implement that IEP. The court also mentioned, and that was not the thrust of their decision, but least restrictive environment, that if we don't provide transportation and are just going to be providing, let's say, homebound services, that would limit the ability of the district in providing the least restrictive program that the child needs. Not that would be easy necessarily for the school district to provide, but the court factored in LRE as also a consideration. And we're going to go, and I'm going to make sure I get through these slides, and then we'll take questions. We have a couple more cases. Least restrictive environment. For those of you who work with the preschool population, here was a child with a profound hearing loss. At age 2, received a cochlear implant. When the child was about to enter the school district, at age 3, the school district developed an IEP. Part of the data that they collected in preparing that IEP is they interviewed the parent. And the parent said, our preferred mode of communication for our child is spoken language, not sign language. The IEP was developed for that child that called for 85% of their day to be in a special ed class for children who are deaf and hard of hearing. They would have 30 minutes a day in recess with typically hearing peers, and 90 minutes a week in courses such as music and art with typically hearing peers. The court, based on the evidence and testimony of experts, held that the IEP would have not provided the least restrictive placement for this child because children, in this case, in order to progress meaningfully in the educational environment, this child with a cochlear implant needs maximum interaction with peers who are typically hearing. There is another element to this case, and I'm going to just briefly explain. This kid needed speech and language services. The services in the IEP said speech and language will be provided 30 minutes per week, 1 to 10 times a week. 1 to 10 times at 30 minutes. So that could mean 10 times at 3 minutes a session or 1 time at 30 minutes a session. It did not specify whether it would be individual or groups services. The court held that the IEP not only violated least restrictive environment, but violated the parents' right to be meaningful participants because they couldn't understand, nor was it explained to them at the IEP meeting. Next slide, please. Remember that the IDEA, especially for children who are deaf or hard of hearing, requires that the IEP team consider the student's language and communication needs. Not what the school district has to offer, but we focus in on the student's language and communication needs. For preschoolers, obviously, that's going to require the input of the parents. The court found in this case, the school did not properly consider a continuum of services. Could this child have been placed in a regular preschool class with supplementary aids and services that would have allowed them that interaction with typically hearing peers? The court said that the team did not properly consider that. Lastly, the frequency and duration of services has to be clearly laid out in the IEP. The school said, well, the parents could have asked a question. The parents said, well, no one even explained to us until after the meeting, and we saw 1 to 10 times a week for 30 minutes a week of speech and language. The court held that must be clearly laid out in the IEP and not dependent on the parent's request for clarification. A couple other cases, and we're going to finish on time. Next slide. A case that's got a lot of publicity from the Washington State District Court. Here was a parent who made a unilateral private placement. They went to a due process hearing to recoup the tuition for that private placement. The administrative law judge held that the parents were entitled to that reimbursement and ordered the reimbursement. The school district appealed to the federal district court, who disagreed and reversed the administrative law judge. And they held, first of all, we find as a district court that the IEP would provide FAPE. And secondly, that the school with the parents placed the child in was not proper under the IDEA. So they reversed the ALJ's decision. 3 months later, the district comes back to the court, knocks on their door and says, we have a motion we would like you to consider, a motion to amend your order. And we are asking that you order the parents to repay us the reimbursement amount for the private placement that the ALJ ordered. And we're not talking a few dollars, $445,000. The court held that motion granted. In fact, if we didn't grant this motion, the judgment would only be illusory because the district already paid this amount. They are entitled to be reimbursed. The court rejected the argument by the parents that the repayment would be inequitable. If we can go to the next slide. This case is on appeal. We will see what the Ninth Circuit has to say and whether this case sets a new line of case law or is an outlier. I am not aware of any case where the parent has been held to reimburse the district this amount of money. I am aware in a few cases where the federal courts have ordered the parents to pay for the school district's attorney's fees. And that one of my favorite subjects that we will not be discussing today is attorney's fees. But this case was for reimbursement of tuition. And the court noted, we have been provided and found no authority to hold that the parents get to keep the tuition reimbursement when the decision that it was based on is reversed by the court. Well, there'll be a practical question. How will this court order be enforced? Because the parents have claimed that they will have to declare bankruptcy because they don't have the resources to pay. So we will see if this order is really implemented or is just kind of an outlier, as I mentioned. Next case. And now this case is going to be dealing with staffing issues. A student with autism, nonverbal, was placed in an autism class for 85% of the day. Nonverbal, 6 to 8 students, staffed by a special ed teacher and 4 aides. The programming in this class, since most students were nonverbal, they used verbal behavioral programming. In October, the special ed teacher left on maternity leave. The district autism coach, who was responsible for, I believe, 6 autism programs in the district, said, I will take over until we find a long-term sub. In the meantime, we'll have short-term subs. Well, the short-term subs, none of whom were taught to provide verbal behavioral programming, included a chiropractor, a librarian, college students. The aides were never given access to the IEP. By the way, the parents were not notified of the lack of a long-term sub or the qualification of the aides until the next school year. At that point, the parent of this child said, enough is enough. And they looked to the neighboring school district that had an autism class and enrolled their child in that neighboring school district, and the parents paid for the programming. They then initiated a due process hearing seeking reimbursement for a public unilateral placement. The court said in this case, based on a great deal of evidence that was presented, that FAPE was denied due to school staffing challenges and issues. And I think they were really bothered by the fact that the parents were not kept in the information loop of what was not happening for their children. The district administrative coach who said that he would be taking over, or she would be taking over in the meantime until they got a long-term sub. There were several days that the autism coach wasn't even in class. So in a 54-page decision, this court held that the staffing issues amounted to a denial of FAPE and ordered reimbursement for a public school placement. The school district said, no, 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 no. The IDEA only allows you to order reimbursement for a unilateral private school placement. The court said, no, 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 no. We have the discretion to award appropriate remedies. To quote the district court, it would be an empty victory for us to tell the parents that they were right, that the district denied their student a FAPE, but that they must bear the cost of the school district's failure, end quote. The court held the parents are not given a choice under the IDA to choose between a free program and an appropriate program. So this is one of the few cases, or only case where I'm aware of, where a court ordered reimbursement for another public placement that was unilaterally made by the parent. Next slide. So the lesson learned is that there's broad discretion in fashioning appropriate remedy. I did want to factor in, we'll see if this is appealed. And I think the Loper case could potentially come in because the IDA does not talk at all about unilateral public placement reimbursement. But let's talk about the common concerns of staffing. And I think this is an issue from every state, and virtually every district has to find appropriate staff to provide services to our children, especially our children with disabilities. When staffing issues or challenges interfere with the full implementation of the IEP, it is essential for school districts to inform me, the parent, of that dilemma. To also tell me, what are our efforts in terms of a Band-Aid approach to keep some services for the student? What are our efforts in trying to find or contract with qualified staff? And depending on the interruption of the implementation of the IEP, the school is going to have to consider determining whether compensatory services are appropriate for that child when staffing challenges are finally resolved. The last case, again, I hate to say it, Ninth Circuit, CD versus at Atascadero. Here was a child who was 16 years old, had a speech and language disability, had a central auditory processing disorder, ADHD, among other disabilities. At one point, the student refused to go to class because he was watching a construction site. Several staff members went to the student and said, now we need you to go to your next class. This is dangerous for you because there's flying debris and so forth. The case manager, and followed the student's behavioral plan in their IEP, spoke with the student and didn't yell at the student, spoke with the student, says, now it's time to go to a safer place. You are in the red zone. And apparently the behavior plan talked about green zones, yellow zones, red zones. And so was using the directive in the IEP and asked the student to please go back to a safe environment. Eventually, the student pinned the case manager against the wall and threatened her. The court defined it as assault of behavior. The student was suspended for 10 school days, pending an expulsion. The school called a manifestation meeting, and the team determined no manifestation existed because the student's conduct was not caused or did it have a substantial relationship to the disability, nor was it the result of the school's failure in not implementing the IEP. It gets to the Court of Appeals. The Court of Appeals said, first of all, we cannot attribute all of a student's conduct to their disability. in this case, we are convinced that based on the unique features of this case, this child's conduct was volitional and was exceptional and attenuated from his disability. So they upheld the no manifestation determination. If we could turn to the next slide, please. I would ask both school personnel and parents to carefully consider whether you litigate manifestation, because I would like you to take some of the energy that goes into manifestation determinations and really focus on services, because regardless of whether it's a manifestation or not, the student is still legally entitled to receive services, both that allows the student to continue to participate in the general curriculum and progress under their IEP goals. So I've seen such energy put into manifestation, and you know that whether it's a manifestation or not, both roads lead back to continued services. And I want to cite once again the OSEP Q&A on discipline that lists in question 5, as I indicated in the slide, that if the parents in the school can come into agreement regarding the IEP for this student who might have engaged in some significant behaviors or misbehaviors, if we could agree to the placement and services that this child needs, it would not be considered a disciplinary change of placement requiring a manifestation. So this is kind of the lesson learned, is to really carefully litigate, because we go to the next slide. On our last slide, there are no winners in special ed litigation. You might prevail, but you don't win. And as Melanie first pointed out in her opening remarks, the law is built on collaborative relationships. And sometimes it's so easy in heated meetings to lose focus of why we're here and keeping the focus on the student. And I hope that both districts and parents will seriously consider at any point we reach an impasse to consider mediation as an option. And I know a majority of states now or have another alternative called IEP facilitation, where a third party comes in to facilitate a meeting, not make the decisions, such mediators don't make decisions, but to facilitate the team. And I think we could do everything we can to avoid litigation, because as I pointed out, there are no winners. On that note, I, for once, finished the materials, and I want to turn it over again with my thanks to CADRE and turn it over to Melanie.
Thank you, Art. The case law and IDA definitely doesn't stand still. We always appreciate your learned take on it. And thank you for keeping an eye on the landscape and helping us understand it. We're always grateful for your analysis. So thanks a bunch, Art. I want to remind everybody about the survey for our evaluation. We would very much appreciate your feedback. It's important to us. So if you would take a few minutes and respond, it's important for our grant. And our symposium is just a year away. So, I guess I should probably move the slides. So there's our survey link, and it's in the chat. And our symposium is going to be October 21st to 23rd of October of next year. So we look forward to seeing you. Please come. And presentation proposals and workshop proposals are currently being sought. We have an RFP out, so please feel free to send one in. We'd love to see you. We'll put that link in the chat. We also have a 2-part webinar that's coming up on November 19th and December 10th. Maximizing participation of the entire IEP team for better student outcomes. So please keep that in mind as you're doing your professional development planning. And I'll just put that one in the chat. And as always, do let us know how we can support your work in promoting early and equitable dispute resolution practices. Stay tuned via the CADRE newsletter and our website for future webinars. If you would like to sign up for the newsletter, you can do so through our website. And last but not least, the last pitch for you to fill out the survey. So thank you all for joining us. Thank you again, Art, our heartfelt thanks, and all of you for joining us. And as Art usually signs off, stay compliant. Is that what you used to say? Stay out there and stay compliant. So, but also stay collaborative, and best wishes to you all. Do take care. Thank you.